Great. Hi, everyone. Thank you very much for joining us for this webinar. It is my distinct honor on behalf of the American Society of International Law Annual Meeting Committee to organize this panel on challenges to liberal-led international law and order. So we have a terrific lineup today, and I will do a very brief introduction in the interest of time. So our moderator is Professor Jacques Deng, who is the director of the Center for the Study of Contemporary China, and Stephen A. Cozen, Professor of Law and Professor of Political Science at University of Pennsylvania, Carey School of Law. His research and teaching focus on contemporary Chinese law and politics, including its legal reforms, Taiwan and cross-strait relations, China's engagement with international orders, and much more. Our panelists include a terrific lineup. First up is Professor Taichung Yang, who is a professor of international law at Fudan University School of Law based in Shanghai, China. Before joining Fudan, he taught at Xiamen University School of Law. And his interests and writing include international legal theory, foreign relations law, international investment law, Chinese international legal policies, and practice. He published a recent book called The Rise of China and International Law in 2019. Professor Ingrid Wirth is an Associate Dean of Research and the Helen Strong Curry Chair in International Law and the Director of Litigation and Dispute Resolution Program at Vanderbilt Law School. She's a leading scholar in foreign affairs, public international law, and transnational litigations. She was named the endowed chair of Helen Strong Curry Chair in International Law in 2015, and is also an associate dean of research at Vanderbilt Law School. She has served on the board of editors of the American Journal of International Law and on the State Department's Advisory Committee on Public International Law, and is also a member of the American Law Institute. And last but not least is Professor Angela Deng, who is an associate professor at the Faculty of Law at the University of Hong Kong. She's an expert in Chinese law and has written extensively on Chinese regulatory issues. And she's the author of a recent book called The Chinese Antitrust Exceptionalism: How the Rise of China Challenges Global Regulations, published with the Oxford University Press in 2021. So with that, let me turn back to Professor Deng to start the panel.
Well, thank you. Thank you very much, May, for putting this panel together. Thanks to our co-panelists for all the thought they put into this. It really is, I think, going to be a terrific session. I'm just going to say a few framing remarks to start with. And one other thing I want to say, just as a matter of process, for those of you who are listening to this live, if you have questions you want to raise, please put them in the Q&A function, and we'll get to them later in our events today. The topic today is challenges to the liberal-led international. I think there's pretty widespread agreement that the liberal international order, the so-called rules-based international order, is in some trouble. The phenomenon and the sources of it, including China, which will be among the topics we're discussing today, has been a focus of a lot of discussion, including at prior ASIL panels. But we have a fresh take on it, and it is something of a moving target. So that's what we're going to get into today. Again, the signs are everywhere of trouble for what we usually mean when we say the liberal order or the status quo international order, including its international law elements. The WTO, the descendant of the GATT, the core principles of economic liberalism there, of reducing trade barriers and making borders matter less, is in some trouble. I think everyone would agree. It's been hamstrung by the US role in understaffing or unstaffing the appellate body. There's been lots of invocations of the illiberal elements within the WTO framework increasingly. We've seen national security provisions invoked. We've seen protectionism generally, particularly from the US under Trump and to a degree still under Biden, the debacle of the Trans-Pacific Partnership here in the States, and the turn to more statist visions of the economy in China, Russia, and elsewhere. We've seen trade sanctions, which are back with a vengeance. We've just seen them ratcheted up against Russia over Ukraine. And we've seen the relative marginalization of the WTO in the trade space as states turn to other kinds of regional trade agreements, some of them relatively illiberal. And of course, liberalism never really took hold that well outside the trade sector in the many parts of the international economy that are increasingly important now, including finance and investment. On the security side, the UN Security Council centered mechanism for international security and its respect for territorial sovereignty, well, it's had its moments. The UN General Assembly in Korea, the Security Council in Iraq, and to a degree in Libya, and we've seen some measures, although with abstentions and vetoes in the Russia-Ukraine situation. But as Ukraine reminds us, the record's been pretty spotty. There's been much criticism of the US, among others, in particularly the US, in bypassing the process for approving intervention. And softer forms of interference have become an increasing focus of concern for those who care about a liberal order, whether it be China's complaint about interference in its own domestic affairs in soft ways, peaceful evolution and so on, or the US concern about Russian and other interference in its own domestic political processes. And we've seen the increasing use, and I think Angela will get into this, increasing use of domestic law to pursue foreign policy ends in ways that sometimes are illiberal, ranging from hostage diplomacy to what we saw with the U.S. lawsuits over COVID from China, and many more, well, shall we say, less sexy versions of economic regulation that have that going for it. Human rights, of course, is full of liberal principles, on some readings including liberal democracy, but it's always had its limits in practice, and we're well past the heyday of the post-Cold War optimism that followed the collapse of the Soviet Empire, the color revolutions, the Arab Spring, and so on. Instead, we see much frustration with violations of liberal human rights in every place from Xinjiang to Hong Kong to Ukraine to Syria and beyond. And we've seen a democratic recession around much of the world, including in the United States. We're in a moment of resurgent sovereigntism, new relativism in human rights, and the UN Human Rights Council is now a focus of contestation over just how liberal the human rights regime should be. And of course, we never had much of a liberal regime in a lot of increasingly important areas like the internet, cyber activity, climate change, and so on. So I want to commend May in particular for titling this panel Liberal-Led Order rather than Liberal Order. And I think that's an important distinction. There is much illiberalism in all those institutions I was just talking about. State sovereignty-centric arrangements allow much illiberalism at home. The trade regime involves a lot of illiberalism, at least as permissive measures. And on human rights issues, we've seen contested views of human rights, some of which are less liberal. And now the question also has arisen of whether the states that have led this order, most notably the United States, are as liberal as they used to be. So it's kind of coming apart on both fronts, perhaps. And since this is titled International Order and not just international law, the last thing I'll say is IR theory. I think the international some reason for concern and some explanation for the phenomenon we're seeing. The U.S. is less supportive of a liberal order than it used to be, much as hegemonic stability theory would predict, with other powers rising and the U.S. no longer able or willing to underwrite the costs of rules that serve its interests less well. Less liberal states, such as China and Russia, are rising and seeking to remake rules and institutions in ways that suit their interests and preferences, much as realism would predict. And it appears that domestic system type matters. It's hard to think of what's going on with Russia today and the longer range frictions between the US and China as not in some way being a second image issue. That is, domestic orders affect international agendas. The constructivist theories of convergence with status quo norms don't seem to be doing so well today. The notion that economic interdependence would solve all of our problems in international affairs has gotten beaten up pretty badly, and the institutions that might reinforce a liberal order have proven to be fairly fragile and vulnerable indeed. So with that quick smorgasbord of IR, I'm going to turn this to a great panel, which can speak to these issues from what I think is really a wonderful range of perspectives and with great depth in things that I've only been able to touch briefly. So let me turn it over without further ado to Professor Taichung Yang, Professor Tsai from Fudan. Take it away, your views on these issues.
Okay, thank you, Jack. It's my pleasure to join this panel discussion. And this topic is really timely, but also very provoking. I think in the following 20 years or so, after the end of the Cold War, Western power, especially the US, endeavors to civilize or otherwise punish non-liberal states they identify for the purpose of universalize the Western conception of liberalism and liberal orders. And in this process, they did not encounter meaningful resistance from other countries, including Russia and China, to permanent number of the United Nations Security Councils. And thus we can see Annie Slaughter's proposed very famous liberal theory of international laws. Slaughter suggested that liberal states behave better than non-liberal states in terms of international laws. Also, she believed that liberal states could, with international law, civilize non-liberal states. Of course, Professor Joseph Alvarez opposed this liberal theory of international laws. Anyways, more recently, however, such optimistic sentiments force and actuality rise in the West. Some Western states and theorists are deeply concerned that some rising authoritarian states, especially China's, will undermine the democracy around the world. And therefore, we can see the US host the Summit of Democracy last year. Also, we can see Tom Ginsburg proposed provoking theory of authoritarian international laws. In addition, we found a very interesting argument that US together with some other Western countries recently proposed they say they will defend a rule-based international law. However, we those they do not clarify what rules means and what it includes. However, for me, before we discuss challenges to the liberal international laws, we should address several ambiguous issues in this topic. Otherwise, I think this topic will misguide us, at least for me. First, how the liberalism should be understood in the international societies. Liberalism is a fundamental value or ideology deeply embedded in the Western world. Based on liberalism, Western countries develop regimes of political democracies, market economic, and human rights. But for me, my view is that the paramount value for the international society is peace. No peace, no anything. And this can be found in the UN charters. And therefore, any action should lose the legitimacy if it would be always likely to intensify the geopolitical tension and engenders international peace. On the other hand, we can see some strategic selectivities when the West extend domestic liberalism to the international society. For instance, on the one hand, the West always urge other countries to open domestic market and deregulate economic controls. On the other hand, however, it does little to address the U.S. abuse of U.S. dollar hegemony. It is well known that largely relying on the U.S. dollar hegemony, the U.S. imposed sanctions against many other countries, including its allies. Second, what the liberal state bring to international order? Certainly, liberal state on some occasions bring out good result. For example, the help to the domestic transitions in some countries. On some other occasions, however, we can see very different pictures. We can see humanitarian crises arising from the wars or military interventions some Western power wage against Iraq, Syria, and Afghanistan, which further breed terrorism. That is the common trend for every countries. We also should not forget that U.S., the most powerful liberal states, openly adopt American first strategies and impose trade restrictions against China. In accordance with the Sanction 301, which the WTO many years ago determined breach with WTO rules. Interesting, Tom Ginsburg, in his book of the Democracy and International Code, he said, it must be stated that a China-centered world, should it emerge, would likely be a more peaceful one than the Europe-dominated world of the past few centuries. A large power, it means China, without a universal ideology, may be less prone to outbursts like those of the United States in the past 2 years, in which notion the humanitarian intervention and regime change have led to greater militarism and destroy whole countries. Third, what means liberal state lead the international laws? Liberal state use, I think, is 3 major means to shape or lead international words. First, power, especially hard power. Second, domestic law. Third, regional international among the like-minded states. Fourth, universal international law, which most of us understand. International should be universally applied to all states. As we can see, as the Western powers seem to no longer maintain their overwhelming state power and predominant role in the international laws making, it seems that they more rely on the second and third means to lead international order. Therefore, I would like to give the 3 very brief arguments. First, when we talk about the challenge to liberal international order, we should distinguish challenge to the West from the challenge to international order. The West may lead the international order, but the West outer order is a part of the international society or international order. Second, since the current international order is not totally fair and equitable, I think it's almost the people should aware of it. So it is justified to be reformed, which some people may be called challenge. Third, the challenge to the West, to some degrees, might mean permits to international order. So that's my presentation. Thank you.
Well, thank you very much. You've given us a lot to think about there. Let's move on to our second panelist, Professor Wirth.
Thank you so much for having me on this panel, giving me the opportunity to speak. I want to offer just a few remarks about China in particular, but also Russia and human rights, and then think a little bit about whether we should strive for a global legal order that is thin or thick, to use the terminology of the description of the panel. So the global competition between China and the US, or between the West and the non-West, and attacks on the liberal-led international order is largely, and I think probably correctly, viewed in terms of technology and trade, but it's also about human rights. And interestingly, it's somewhat difficult, I think, to tell the extent to which human rights are a pawn that all of the countries are using as a part of their economic, trade, military, and power disputes. That is, whether human rights are basically a cover for different kinds of actions, or the extent to which human rights is actually a motivating factor that is generating different approaches and different worldviews, and splits between countries. In either case, China in particular has been very eager to engage in international human rights discourse over the past 10 years. China has launched really a full-bore initiative, not just to sort of defend its human rights record, but really to shape international human rights law as a whole. As part of its participation in the Universal Periodic Review process in the United Nations Human Rights Council, China really almost launched kind of a new approach that specifically focuses on a human rights development path that prioritizes the right to development, economic rights, and in particular, China's success at lifting hundreds of millions of people out of poverty as a real human rights achievement. In this, China's approach is a move away from the principle of universality. And I think, as Jacques said in the beginning, there was some optimism, post-Cold War optimism about universality of human rights. That really isn't even part of the discourse anymore. China's approach also includes an emphasis on sovereignty, a softening of enforcement measures, underscoring of the bedrock principle of sovereign equality and non-interference, a principle of mutually beneficial cooperation, That's an effort to minimize the naming and shaming resolutions in the UN Human Rights Council. And there's also an effort to make human rights a state-to-state relationship, kind of cutting out civil society. I'd also note very recently, China and Russia released a long joint statement, actually in February of this year. And it's fascinating to me that that long joint statement leads with a statement of values. It leads with references to human rights. And in particular, it leads with a statement about democracy. And it's clear that the two countries are positioning themselves as champions of democracy. Now, I think one of the reasons I find this interesting is that a number of commentators have wondered whether the outcome of the war in the Ukraine will be a much greater entrenchment of conflict between the democratic West and a non-democratic group of non-Western countries. That is, are we going to see kind of a revitalized West around democratic principles? If so, if that is the way that global divisions are increasingly framed, the China-Russia statement from February shows that those two countries are absolutely going to position themselves as equally democratic as the West. They are not going to cede the term democracy. The statement says that democracy is a universal human right, not a privilege of a limited number of states. Democracy is a means of citizens' participation in the government. There is no one-size-fits-all template to establishing democracy. A nation can choose the forms and methods of implementing democracy that would best suit its particular state. Democracy should not be the basis for criticizing one country's approach and supporting the others. Russia and China have thousands of years of experience in creating democracies, broad popular support, and consideration of the needs and interests of their citizens. And again, there's this emphasis on other countries' attempts to impose their own democratic standards to monopolize a certain version of democracy. These things are denounced in the statement. So why is this significant? As I've already suggested, I think it suggests that China and Russia foresee a conflict, a power conflict that unfolds in value terms, and they want to make sure that they complicate and co-opt that language. And as Jacques has said, there are certainly a lot of problems with democracy in the West, not the least of which in my own country, the United States. We can leave the war in Ukraine for discussion, but relatedly, we see Russia's very clear articulation that the war in Ukraine is consistent with international law, based in part on self-defense, based in part on humanitarian objectives. Russia mentioned the very many questionable objections, the very many questionable interventions by the West and the United States, which those countries defended as fully consistent with international law. This, of course, is a move from the human rights playbook, in which countries seize on other countries' violations of human rights while minimizing their own. The audiences for these statements, I think, are domestic audiences in part, right? Domestic audiences in Russia, to some extent, domestic audiences in China. But I think the audiences are also non-aligned states or states that haven't fully condemned the Russian intervention. So going forward with human rights, I think really representing perhaps a greater and greater division in the world. What can we expect international law to do? What do we hope that it can achieve? My own view is the very, very basic divisions in the way countries see human rights suggest that we might want to try for, at least in some fora, a thinner international legal approach in which human rights are not given as great a significance. So, for example, one of the changes in the UN Security Council over the last several decades has been an increased engagement in human rights. peacekeepers around the world are increasingly tasked not only with keeping peace, but also with human rights. I would simply suggest that we think about whether international law and international institutions, perhaps, especially in light of the war in Ukraine, should be reoriented around a smaller set of norms designed to prevent war and threats to peace and security, and whether we should pursue human rights, which I believe are vitally important and probably have never been as important globally as they are today. That it may not be that all international institutions can do all things equally well. And to that extent, I would suggest that we think about thinner ways of encouraging global cooperation. Those are my opening remarks.
Well, thank you very much. And before I turn to Professor Zhang, I just want to again encourage people who are listening to this live rather than recorded. If you've got questions or comments, please put them in the Q&A function. Angela.
Thanks, Jack. So first of all, I need to start admitting that I'm not a public international law scholar. So I'm pleasantly surprised that I'm invited to speak on this panel hosted by the American Society of International Law. And I accepted the invitation partly because I cherished the opportunity to speak with 3 luminaries in international law on this panel. But I also secretly thought that perhaps there is value for me to contribute my viewpoints as an outsider to public international law. So my remarks below will focus on more like a private international law, particularly on the kind of legal wars that we are seeing that is posing a threat to the so-called liberal-led international order. And I will focus my remarks on 3 aspects. First is the trend of increasing adoptions of sanctions and anti-sanctions in major jurisdictions. Second is the growing suspicion of foreign digital platforms and the exertion of digital sovereignty. And finally is the weaponization of domestic law, particularly laws that are supported by the supply chains to advance the country's foreign interests. So first about sanctions, my panelists have already mentioned them. So these are featured very prominently in the headlines these days in the Ukraine and Russia war. Actually, public international law is not featured prominently. It is the sanctions that is the real weapons that are being used to tackle, to deal with Russia right now. And we all know that America is a country that likes to use sanctions, from trade sanctions, financial sanctions. And before, it mostly applied to hostile interests. Countries like Iran, North Korea, Venezuela, Cuba, and Russia included, and recently been applied to China. And this sanction law can be applied extraterritorially based on very little US nexus, right? Just like using the dollar or using Gmail or using the Android operating system. So basically it's very easy for the US to exert jurisdiction in those cases. And as Taichung Yang mentioned, right? I mean, not just those hostile countries that were sanctioned, but also, America's airlines, like European companies, European banks were fined before for violating US sanctions. And China learned its tough lessons during the trade war, when Huawei and ZTE were found to have violated US sanctions against Iran. And in the current Russia-Ukraine crisis, America had repeatedly warned China that it could subject itself to sanctions if it is found to, provide aid to Russia, right? This has been in the headlines these days. Now, look, America's exertion of this long-arm jurisdiction and the extensive use of sanction law has provoked many countries to adopt anti-sanction law. So China adopted the anti-sanction law last year, which empowers the Chinese government to seize assets from entities that implement sanctions against China, and also to hold businesses liable for refusing to help Beijing carrying out anti-sanction measures. And who's the casualty from this? Well, it will be the foreign multinational businesses operating in China, right? I mean, because they will be operating in a kind of like a hot and raw place. Back to the Ukraine crisis, suppose if the United States impose sanctions on the Chinese Chinese individuals or Chinese bank for assisting Russia, then those banks, right, I mean, could be found to be simultaneously violating Chinese law, and that's a really difficult position for foreign companies, and they have been there before, right, with the Hong Kong national security law. So a lot of companies were extremely worried. Now, for sure, no countries as of now have the political and economic clout to really counter the US sanctions, but time may change that as the economic and geopolitical power shift over time to the east. But for now, I mean, multinational companies that operate in multiple jurisdictions, they will face these increasing difficulties in navigating this conflict of law in different jurisdictions. The second conflict that I saw arising from this challenge is this growing assertion of digital sovereignty that have artificially carved up our digital world, the global internet, into, you know, what Mark Lemley said, it is like a splinternet, right? I mean, so countries are imposing stricter data security law to guard their national interests. So China had the cybersecurity law back in 2016, and then last year adopted two bodies of data law, national law, data security law, and personal information protection law. Both laws limit cross-border data transfer. And Didi also ordered its largest ride-hailing company, Didi, to delist in America for, you know, cybersecurity issues. Although there's actually no evidence that Didi is sharing sensitive data with the U.S. authorities. Now, Europe also have rows with the United States regarding the adequacy of the U.S. data protection of European citizens, and that has resulted in two EU Schrems case and rounds of negotiation between the US and EU regarding the EU and US privacy shield. Now, even the United States, being the most liberal in this regard, is having growing hostilities against foreign countries, particularly, you know, companies from China, right, that are operating in the United States. And that explains the Trump administration's threat to ban TikTok and WeChat, as well as its ban on Huawei. Now, similar to sanctions, I believe the restriction on data flow will again present another fundamental challenge to the liberal international order, making it very difficult for multinational business to navigate this highly complex and uncertain and ambiguous data cross-border data issues. And lastly, is the weaponization of supply chains to advance a country's foreign interests. The United States has imposed very strict export control laws on Chinese tech firms, and now, you know, also imposed very strict export control law to Russia. America has also introduced foreign product rule that restricts anyone that use American equipment to make the good, even if there's no US content inside. So it's a very broad application. Now, China is learning all these tricks, right? I mean, China is similarly weaponizing its supply chain to impose sanctions on other countries, smaller countries like Lithuania. And, you know, Russia is doing that. Russia has threatened to cut off gas supplies amid the war with Ukraine. So every country at the moment is seriously thinking about self-sufficiency. Even for Europe, it's feeling insecure about the semiconductor supply. So, you know, my portray of these three, you know, my discussion about these three challenges does seem to lead us to a gloomy prospect of, you know, a clear trend of deglobalization, where you see nationalism on the rise and fragmented digital space. And as Jacques mentioned in his opening remark, right? I mean, we all know there's abundant literature that globalization make it more costly for countries to engage in conflicts, whereas deglobalization do reduce the cost for countries to do that. And as a scholar from China, I'm deeply worried about this trend. And actually what worries me more is that there seems to be this growing emphasis on ideology of this kind of two camps, you know, the liberal and non-liberal order. And there's less call for pragmatic engagement. And this is something that I believe will be the greatest threat to the liberal international order in the years to come.
Okay, well, thank you very much. Thank you, panelists, for giving us a lot to think about here. I do encourage anyone listening to put questions in the Q&A function. We've got at least one there at the moment. So I want to pick up on something that I think is in the Q&A box, which I think all of our panelists can see, and that I think comes out of all of your remarks, which is basically, I think, provoked by Ingrid's comments, that we are facing, obviously, illiberalism in a variety of contexts here. And the question is sort of what we do about that. And the questioner in the Q&A box asks, how much are we talking about a crisis of liberal international law? And how much are we talking about a crisis of international law, that is having rules that can deal with it? So one possibility, which Professor Wirth has suggested, is we get a little less ambitious. We seek a thinner international law, maybe having different institutions doing different things. And so I would turn that to our other two panelists, if that's their view on these things. We seem perhaps to have lost Professor Tsai and the problems of internet connectivity. So maybe I'll throw that to Angela. So do you think that the way out of this path is to just have more, or this problem is to have just a thinner expectation of what, particularly in the economic realm that you're focusing on, expectations of what international law can do?
Well, because I'm not a public international scholar, so I'm not deeply entrenched into your area. And so I can only offer my viewpoint from an outsider. I believe that international law have done a lot, in building all these international institutions. But however, I haven't seen its relevance very recently. And I do agree with Ingrid's comments that perhaps the thinner international law will be more pragmatic, because when it is thicker, when it is imbued with so much ideology and norms, it actually restrains a country's ability to act very nimbly, particularly in a very difficult crisis, right? I mean, such as the Russian-Ukraine war, when you have so many different moving pieces, so many overlapping and conflicting interests that you need to handle at the same time. You really need pragmatism rather than ideology to handle this. Because at the end of the day, as Yang was talking about, if we want to prevent humanitarian crisis, we want to preserve peace, we need to do something about it, rather than reading the books and tell us what you need to do. I just coming from a layman perspective.
Okay, thanks. I think Professor Tsai is with us at least on audio. So I would encourage him to weigh in on this question of whether our way out of the crisis, as it were, in a liberal or assertively liberal international order, whether we should just go to a much thinner, more modest conception of what international law can do. Taichung Yang, are you there?
Okay.
Yeah. I think we're having bandwidth problems. We're not.
I think it's
all right. Well, I'm afraid. So again, I don't know if you can hear us, but if you can, I think you may need to deconnect and reconnect. We're really not getting the audio. Okay. We have another. Oh boy. Okay, we have another question in the box here. I'm going to try and message. Try and message him. Hopefully that will get through. Okay, we have another question that says China has shown a preference for informal sanctions to exert economic pressure to resolve diplomatic disputes. What do you make of China's recent formalization of its sanction mechanisms and the increasing number of retaliatory provisions scattered in recently promulgated or amended laws? Well, we hope we'd have Professor Tsai able to answer that. Angela's spoken to some of that. I would just throw it to her in a second, but I would supplement perhaps by saying I think that's what we're seeing. It's imitation is the sincerest form of flattery, and if you go through what China has been doing, it's been essentially reading from the U.S. playbook of national security restrictions, of on investment and on trade issues, and of invoking a variety of means of scrutiny, which can always be defended as serving the kinds of ends we'd see, but that are, this is, okay. Oh wait, Professor, so yeah. Yeah, okay, that's. Oh, right. I think we're clearly having some communication issues. Maybe if someone who's on the hosting end of this can try to get a message through to Professor Tsai about the issues we're having here. Ingrid or Angela, do you to that question about China's formalization of its sanctions mechanisms and the resort to retaliatory measures that, again, look a bit US-like?
Well, I can speak briefly about that. Well, I see what China is doing is a further escalation of a tit-for-tat war against Americans' aggressive use of sanction laws and various restrictions to Chinese companies. Well, from a game theory standpoint, like when someone provoke at you and China have to do something in return, otherwise it will show that China is weak. However, if you look at the law itself, China promulgated the non-reliable entity, threatened to impose a non-reliable entity list a couple of years ago. And then I think it released the law a year ago, but so far, no company has been really put on the sanction list, right? And there is the anti-sanction law, but they didn't, really implement it, haven't been, with exception of a few very symbolic sanctions, they haven't been very high-profile enforcement. So I think from a China standpoint, I see this as, China wants to have this weapon in place to serve as a purpose of deterrence. So in China's best interest, China will hope it will never need to use this law because these laws are self-destructive to China, and China is acutely aware of that, right? I mean, China is at an economic slowdown. It needs foreign capital, right? I mean, this is the first and foremost worry for the Chinese leadership at the moment, right? I mean, our premier just have a meeting today assuring the international capital market, don't go away from China. We need you, right? I mean, we still want to achieve 5.5 GDP growth this year, right? So China will be extremely cautious of rolling out any substantive sanctions against foreign firms for fear of driving away foreign capital. However, at the same time, it wants to create these weapons in place, when it really go to that, that point, we might retaliate. That's how I read about this.
Okay, thank you. Let's again briefly check and see if Professor Tsai's audio is working. Okay, apparently not. All right,
so maybe he's in Shanghai at the moment, and there's some issues with Shanghai's COVID control might be affecting his internet connection.
Right. Well, this is one of the downsides of our Zoom age is we think we can all be effectively in the same place, but it doesn't always work. I want to sort of extend the question we were just talking about to Ingrid's discussion of human rights. So we've seen a lot of this sort of tit-for-tat sanctioning and this invocation of a variety of issues, including unfair economic practices and national security threats. Ingrid, in your initial remarks, you spoke to this emergence of rival interpretation of human rights and democracy. The US and other states famously use human rights and democracy and other such bases for imposing sanctions. Do you see somewhere down the road a Russian or Chinese equivalent? Will we see the imitation, the sort of mirror image stuff where alternative or rival conceptions of human rights will be used as a justification for some of these economic measures that might target Western states?
Absolutely. I think at the moment it's probably just economic power that's driving that calculus, not any, I don't think China and Russia would be shy at all about sanctioning the US for human rights violations. And this just goes back to, I think, what Angela was saying. If they felt like they had, if they felt like it was in their economic best interest to do so, and they had the economic power to do that. What's interesting about the technological side of it, and I found Angela's remarks really, really helpful, is again, when you think about national security and to some extent data protection, I think almost, and I'd be really interested, Angela, on your views on this. I think most of the conduct in that space is national security driven, but there's always a human rights underpinning, right? So Huawei in Europe, right? Mostly it's about security, right? Do we need to worry about our technology platforms? Do we need to worry about the back door? But there's also this undercurrent of, wow, this technology can be used in a really repressive way to limit human rights around the world. And the same thing goes with Chinese sale of a lot of technology to use facial recognition. And I think China's defense of human rights in that sense is quite bound up with this trade agenda, that no, you can really have a great human rights approach to human rights that's very development focused, and you can buy our facial recognition software, and that helps you become a human rights protecting country if it builds your economy. But I'd be curious to hear from you, Angela, how much you think, is are human rights driving any of this, or is it just a narrative that's sort of secondary to national security and economic concerns? I can actually see, after Ukraine, I can see human rights actually driving some of this in terms of where the West decides to shop and how it decides to become networked, but that's just a prediction.
Right. I see these two things, national security and human rights concern, are actually intertwined, right? The fact that we have suspicion and distrust in a regime that may not, properly protect our citizens' data is the fundamental reason that is creating the tension here. No company, no technology company, whether we're talking about a US technology company or a Chinese technology company, can credibly commit to say they will never turn over their data to their own government. United States have the Cloud Act, China have various data law, EU, I believe, European countries have similar law. Even if they have similar law, their countries have a basic obligation to conduct surveillance over their own people, right? Every country has spy and surveillance, function.
For example,
and the US has a massive surveillance system.
Can you hear me?
Yeah. We're having some significant audio problems with Professor Tsai, who I think probably can only hear us in bits and pieces. We can only hear him. He says he can hear all of us, but we're having a hard time hearing him. I guess, given the connectivity discussion problems, and since Professor Tsai can hear us, I think maybe the best we can do is, if Professor Tsai has comments on some of the issues, I hate to ask him to do this, but if he could type it into the chat function and send it either to me or to fellow panelists or to everyone, and we'll try to incorporate that in our discussion. One thing that I will throw out now that's in the Q&A box that I'm sure Professor Tsai has views on, but we can discuss it as he perhaps types in his views, is one of our questioners asked, is it possible to have essentially two different systems of international law? We've been talking implicitly about a universal and somewhat, if not completely, liberal system that is under some assault by China and Russia and other countries that have different conceptions of some of these things, as well as internal erosion, lack of support from what we think of as liberal states. And of course, that's a question that in a way harkens back to an earlier time. In the early days of the People's Republic of China, there was a notion of, and the Russians, the Soviets were part of this too, there was a notion that there were two types of international law, right? There was so-called bourgeois or liberal international law, that was the law among Western states by and large, and East Asian states and others that had gone down that path. And then there was socialist international law among the states who were on that side of the basic system divide. And then there was a thin general international law that linked the two. So is this a case of back to the future? Can we foresee a kind of blockism in international legal orders, which one can imagine happening if we see Russia and China go further down the path that Ingrid described. I think very much in the joint statement that Xi and Putin issued on the eve of the Olympics and other matters we've seen. And if we see increased economic decoupling, you can see going down that path. So is that potentially in the cards? I really wish we could have Professor Tsai weigh in on this orally. Perhaps he can do it in a written form. But I invite Ingrid and then Angela to weigh in if they want to on this.
I'm happy to weigh in. I mean, and this goes a little bit to, I think, Mark Pollock's excellent question too. I view them as intertwined. Yes, I think there is a threat to the rule of law, if you can even call international law in all contexts a rule of law. And one of the threats is that we wind up with this two-tiered system that Jacques and Max, the comments have referred to. I think it's really important that we try to maintain a global international legal order. I think that's of incredible significance. I think that Article 2.4 of the UN Charter is under a great deal of pressure at the moment. And I think it might, to the extent there's a trade-off, we could maybe insist a little bit less on the liberal character of international law across all domains and focus more on the prohibition on the use of force and the preservation of territorial integrity. I'll just want to really emphasize that in no way means that we would give up on other objectives that are important globally. We just might not pursue them through international law. The political science data tells us that the most dangerous interstate conflicts are conflicts over territory. The disputes that are likely to lead to regional and global wars are not disputes about trade. They're not disputes about ideology. They are disputes about territory and borders. I happen to think, if you look historically, there's a lot of reasons to think that the conflict in Ukraine, especially if it unleashes other territorial conflict, is potentially incredibly dangerous. Might it lead to a reinvigorated international legal order? Sure, it might, and let's hope it does that. But from my perspective, a place where we could really emphasize territorial sovereignty, territorial integrity, and interstate peace would be a welcome place in international law, even if it compromises a little bit on other values.
Yeah, I definitely agree with Ingrid. I'm a scholar who is both trained in China and United States, and I interact with people on both sides, and I read newspapers from both sides. And from what I have seen, it does seem to have two different versions of the world, as Ingrid mentioned, right? I mean, China also talk about human rights, talk about democracy, and it's a different versions, right? I mean, they are not, neither side is being heard at the moment, right? I'm talking over each other. So I will put all the rhetoric aside. And at the end of the day, it seems like these great powers, what is driving the tactics ultimately is still about interest, right? I mean, there's no lasting friendships, no lasting enemies, and only lasting interests. We still recall the 1979 when Kissinger and Nixon went to China, right? I mean, and came closer to China, and being this, and get China being more distant from the Soviet, right? I mean, anything can happen. I just feel a bit more pessimistic these days because we have too much rhetoric, too much emphasis on rhetoric, too much catering to domestic audience without really taking very pragmatic resolution to deal with the humanitarian crisis that we are facing in Ukraine right now. And that's something that as a scholar, I'm deeply worried and concerned about.
I just note that Professor Tsai weighed in the chat in response to this question. He says he thinks the notion of a dichotomy of international law, one set of laws for one group of states and another set of laws for another group of states, is outdated. That would be, back to a path that he, I gather, neither endorses nor thinks is terribly likely. There was another comment in the Q&A function that I think is worth noting, which is this is a somewhat pessimistic panel, I think, the way we're discussing it, but I think we would all agree that what we're talking about is essentially downward turns from what had been some remarkable accomplishments, and the degree to which the post-war liberal order did achieve a great deal of success, and that China, for all of the concerns now about its impact on this order, does have some merit to its arguments about what it has contributed globally and to its own people and so on. So, it's all a matter of baselines, and I guess whether you think glasses are half full or half empty. And again, Professor Tsai reminds us that he doesn't think it's going to come apart and spiral down that path. One of the things I think comes out of much of our discussion here is the degree to which everybody seems to be arguing that they are behaving infra-leg, they're working within the law as it is and not really openly challenging it. And we can see that across a range of issues, right? So the position from countries like China and Russia are that this more sovereigntist notion of human rights, that a sort of less liberal focus is perfectly consistent with the human rights order, that the kinds of protectionist measure and national security justifications that are offered for things that break up economic liberty. And we could look at other examples too, right? The arguments in the South China Sea, the arguments for intervention that the US has pursued, and so on. There is a remarkable resiliency to the idea that these things are being done within legal framework. So is this just the old saw about hypocrisy is the tribute that vice pays to virtue, or is there actually something to be hoped for in the attempt to keep this within the frames of law, or is it all meaningless, and or are we headed toward a breaking point where those kinds of arguments are no longer made? So, small question, but before throwing it open to you guys for that, I got another message here from Professor Tsai, who says, of course, as China becomes more powerful, it will seek a larger voice in international law, but this does not mean that China has the intent to create a new order. For instance, the AIIB governance is based on the World Bank, Asian Development Bank, and so on, the Asian Infrastructure Investment Bank. And that is certainly, I think that speaks to the question we just addressed there. So thank you, Professor Tsai, for weighing in on that. Let me throw it first to Ingrid and then to Angela on this topic of well, I won't restate the question. That's our team.
I think, your question has so many aspects. One is what we even think of as international law. We can think of international law as a set of rules, and then we decide who's violating and who's not. And I think that works, international law works that way, maybe in some contexts. We can also think of international law as a set of norms or a language of discourse or a process. And if you think of international law in that way, I think the question, which might be an unusual way to think of it, but the question makes a little bit less sense because, this is what international law is, right? We, countries take actions that are on the margins of international norm, and then we have a conversation about whether we're in compliance or not in compliance. And in particular, custom has this character to it. That's kind of what custom is when it comes down to specific examples. So there's kind of the broader jurisprudential question of what even is international law in the broader context. But I think it continues to have force in even Article 2.4. But I will say it feels like we're at a kind of tipping point with Article 2.4, and I absolutely think it is Western interventions, and we can start with Kosovo, as well-meaning as that was, that really was the West sort of wrapping itself up in an extremely convincing mantle of not violating international law. And this in no way justifies Russia's conduct in Ukraine. This is not a moral justification, nor is it a legal justification, but it is simply a fact that a lot of the conduct of the West has softened these norms, and in my view, have made it easier for Russia to put its own conduct in the same category as Western actions. And that was a really incomplete answer, but I'm going to let Angela weigh in.
Yeah, and I think that's a terrifically helpful point. And to distinguish between sort of simple both sidesism, which is, yeah, you violated too, and the sort of subtle revisionism or reform by trying to take admittedly vague and contestable concepts and tweak them in a direction that serves your interests. I think we see both going on. I would note that we're up against what is our formal time limit, but May has said we can go up to 10:15 if that's okay with the people on the panel. So I want to throw this question to Angela. We've got one in the chat that I sent to Professor Tsai, so hopefully he can read that. And then at the very closeout, we got to talk about Ukraine explicitly because that's the moment we live in. So Angela first.
My comments will again echo what Ingrid has said. There seems to be in kind of like a race to the bottom among countries, promulgating a lot of laws, sanction laws, weaponizing domestic laws, and then dressing them up as kind of legal arguments where on the surface, but underlying is actually less law because these are not, really driven by legal principles, but more driven by interest, politics, and the application is very fluid, very uncertain, very ambiguous. And even for the United States, when it comes to those sanction laws, there's very little checks and balance, when it comes to actual enforcement. So it does, this area of law does seems to me to, stay out of the realm of the rule of law, particularly when we talk about laws that concern foreign interests. So I do see kind of like a dichotomy, that a simultaneous increase of law and a decrease of law in the international order at the moment. And overall, this is like a regulatory competition among different regimes, right? I mean, it's a race to the bottom that we are seeing. Countries are engaged in tick and tack, legal warfare against each other. Law is featured prominently everywhere, but there's less law at the same time.
Okay, we have a question which I think will be very congenial for Angela, which is the area in which these public order questions we've been talking about spill over into private company behavior. And so the questioner says, to what extent are private companies either being used by governments to achieve geopolitical ends, or are firms on their own helping governments achieve their objectives through their own behavior, such as Western firms pulling out of Russia? And the questioner asks, in the context of the law particularly, how do Chinese laws enable the government or not to shape the behavior of domestic private Chinese firms to realize its geopolitical goals? And of course, one could ask the same questions about the US. And Professor Tsai kindly gave us a written answer to this, and he points to China's anti-sanction law. This is something Angela touched upon earlier. It's essentially a blocking statute. And that is one measure of trying to, I think, push back against corporate behavior that is seen as serving other governments' perspectives. And he notes that up to this point, the anti-sanction law has never been used in China, but it's in the repertoire. Angela, do you want to speak to this first? Oh,
yeah, I mean, there's
one more thing. I got another message from Professor Tsai. Over time, he is concerned that Chinese enterprises may also be weaponized in terms of their engagement in the U.S. And I would this is me speaking, not Professor Tsai, but we have seen a lot of discussion of the degree to which Chinese firms, even private firms, are under some degree of political pressure. We've seen what's happened to some of the more potent, more notable firms like Tencent and Ant Financial, Alibaba, where there is some expectation of not being out of step with government priorities. And of course, we've seen this entanglement of state agendas and firm behavior, partly in the context of U.S. sanctions. So obviously the Chinese government got involved in the measures the U.S. took that were near death penalties for Huawei and ZTE. we see this sort of thing going on. So let me turn it to Angela and then to Ingrid on this topic.
This question actually ties back to the question that Ingrid asked me earlier, right? I mean, at the end of the day, no company, whether we are talking about a Chinese company or a US company, can make this credible commitment that they will never turn over, the domestic the data to the foreign government, right? I mean, in the Chinese company's case, it's the US government is worried that companies like TikTok is turning over, this lip singing teenagers data to the Chinese government, right? I mean, maybe the Chinese military will make use of that. In the case of, Chinese companies, the Chinese government is worried about, the US securities regulators getting hold of China's DD's, the biggest ride-hailing company's data, and we know all about maps, and this can generate national security concern. And look, I mean, whether you're talking about US or China, there's laws that will force these companies to turn over data to their government, right? The US has the Clouds Act. China has a Cybersecurity Act, as well as a lot of new laws. But of course, there's more distrust about how China will enforce the law. And, because of the Chinese private companies will have less resistance than the US counterpart in challenging their own government. But, we're talking about not a qualitative difference here. We're talking about quantitative difference. Even if you successfully fight against your own government in the United States, the US government can still come over and get your data through the back door, right? I mean, that's what we learned from Edward Snowden's revelations of the US massive surveillance systems over its own companies, right? So yes, corporate power can always be used to facilitate, where it goes by the government, and the government don't necessarily need the company's cooperation or permission to achieve that, particularly when it comes to data. And because of the enabling of the technology that enable governments to do that. And at the end of the day, other countries have more suspicion about Chinese companies precisely because of their distrust and hostility towards the Chinese government. So far, nobody can identify that TikTok has done anything wrong, right? I mean, but it was this threat, this distrust, this insecurity that makes people worry about TikTok. And that will be, always an overhand over this Chinese company. However successful it will be, it could be, banned, the next day in America because of that.
Well, thanks. I just want to note we got another message from Mr. Tsai. He says that he agrees that over time, all enterprises have to be affected by their government's position. Private business seems inevitably to be involved in power politics and state agendas. We've talked about some of that going on the Chinese side, and a little harder to unpack the forces driving so many Western firms to get out of Russia. Is that their own preferences, shareholder or consumer preferences, a sense of the U.S. government's position, and all of that. Sorry, one more thing. Professor Tsai here says clearly China does not embrace Russia's. Different. I'll say that for another question. Ingrid.
I don't have much to add. Angela's the much more of an expert on that. It will be very interesting to see, however, how the Ukraine sanctions play out. So, one of the historical developments is the United States has now frozen Russian assets, including Russian central bank assets. And if history is any guide, there will be a lot of political pressure over time if those sanctions remain in place in terms of what we do with that frozen money. Right, we might turn it over to commercial interest corporations who are creditors of Russia or Ukraine and don't get paid. We might turn it over to help the people of Ukraine, and of course, corporate interests have traditionally played a major role in thinking about how frozen assets get turned over and what happens to them. But that's only a footnote to the much more comprehensive answer that Angela gave.
Right. So of course, an Iran assets tribunal redux, perhaps in this context. But I think it's also implicit in the discussion we've just been having is the degree to which there are flat out legal orders. Right. There are orders to seize assets. There are orders to disconnect SWIFT and all these kinds of things that are corporations not in any subtle way being an instrument, but essentially being regulated in ways that constrain their activity. We've talked about a bunch of export controls and so on. So we've got just a few minutes left, and we've touched upon it a couple times, but given the moment, we have to talk about what the Ukraine crisis means for all of this. I put it in the chat to Professor Tsai, and what he wrote back is, really, China does not embrace Russia's action, and most of Chinese international lawyers consider Russia's special military action as an act of aggression, but we should that Russia is not the only actor that is at fault or should be accountable for the crisis in Ukraine. I don't want to put words into Professor Tsai's mouth, if that's the word for what comes in written in a chat. But of course, if you look at official Chinese statements on these issues, one of the recurring themes has been that whatever one thinks of Russian intervention, that part of the story here is the NATO expansion to Russia's doorstep, a sense of a kind of alignment of democracies in ways that Russia perceived, and I think in the Orthodox or official Chinese view, legitimately perceived as security threats. And of course, then the question is, what does that analogy mean for China as it looks around its periphery and sees the U.S. agenda for the Indo-Pacific, which looks a bit like an alliance of democracies that have an agenda rather different from China's, and those analogies are being drawn, even as we see a strong disanalogy being presented from the Chinese side between Ukraine and Taiwan, right? The argument that Ukraine is a sovereign territory that should not be invaded, maybe not as much distancing from the Russian position as many outside of China would like to see, and some inside China would like to see. But the insistence that Taiwan is a very different case, not recognized in the international system as a sovereign state, and in the Chinese view, indisputably already part of Chinese sovereign territory. In other words, a view that sounds kind of like Putin's view of Ukraine, but that is seen as having, certainly from the Chinese view, much more of a basis. We could talk about that all day. We got a couple minutes left, so let me invite Ingrid to weigh in on this issue and close this out.
Gosh, there's so much in what you said. It's a little hard to know where to begin. I guess I'll focus on something we haven't really talked about China and Russia and the West, and that is the role of the UN Security Council, what we can expect from the Security Council. I think there's a sense the UN Security Council is going to be significantly weakened by what has happened in Ukraine. It's difficult to imagine the US and Russia making much progress on many items in the UN Security Council, given the level of tension, not to mention other members of the Security Council. And I'll just take that to bring it back to something that you said, Jacques, about look how much international law has achieved in the post-World War II period. I think that's right. I would remind listeners, however, that the 19th century was a very peaceful, parts of the 19th century were incredibly peaceful in Europe, and it looked like we had solved the problem of interstate or global war. And that turned out not to be the case. And the concert of Europe, the concert of Vienna, I think was actually helpful in allowing an informal forum for great powers to talk. Obviously, is it an incredibly flawed system? Absolutely. So I'm not really defending it in any normative sense, except it's something to look at as we look out across an increasingly dangerous world. And I guess that kind of brings me back to what is the place where the great powers talk, and part of that is the UN Security Council. And so I would hope we try to make the UN Security Council a place where there can really continue to be some dialogue and some conversation. And if it can't be in the UN Security Council, I hope we find other perhaps new fora for great powers communications.
Well, thank you, and I think we're really hard up against our deadline for how much overtime we're allowed to go into. I would just echo the views we've heard from all of our panelists that while we all would like to see international law play a positive role and recognize the contributions it has made and that the states have helped shape it have made, not always clear that more law better. It really depends on how functional it is and how much it ameliorates versus exacerbates conflict. One thing I would say in terms of the theme that started all of this, which is the impact on the existing international legal order, particularly the impact implicitly of Russia and China and other such states. One of the things that may be a fallout of the Ukrainian crisis is that a pattern we had been seeing, which was a fairly potent alliance, or at least alignment, of China and Russia to push certain agendas of change within the international order, that may have gone off the rails. I think Russia is more an albatross than an ally at this point for what China wants to pursue, and that I think changes the way China might pursue it, and it's going to put some stress on tactics that I think had been somewhat successful. And does that mean that the challenges or the agenda of revision or reform pushed by China is now going to be harder for China to achieve within the system? Does that create temptations to go more outside it? That's something we can watch, and I'm sure we can convene a panel again in a future ASIL on this. So thank you so much, Angela Zhang, Ingrid Wirth, and especially Professor Taichung Yang, because he had just, I think, really heroically tried to fight through the connectivity difficulties, and I thank him for putting comments in chat, and I thank you all for joining us. If you've joined us live, thank you for the questions, and thank you for joining us today. If you're seeing the recording, well, I hope you've enjoyed it as well. Thanks again to Mei Nguyen for putting together this panel and to ASIL for hosting it.